6. And remember, please move.
I so move, Mr. Speaker.
Let me second that.
I so second, Honorable Speaker.
Who is the second?
I have Joseph next time.
All those in favor say aye. All those in favor say aye. Those against say nay. The ayes have it.
Record of votes and proceedings for Wednesday, 5th August 2026 and Friday, 7th August 2026 has been adopted.
Proceed.
Announcements by Mr. Speaker.
Committee chairman, with the exception of those committees that went on oversight during the last session but did not lay their reports, with the exception of those committees that went on oversight but did not lay their report, all committee chairmen, make sure you submit your concept note to the leader of government business for vetting and for my final action. Committee chairman, and of course, committee chairman and their clerks. With the exception, honorable members, I gave deadlines, 2 separate deadlines relating to committees that went on oversight. Of course, I indicated clearly to those committees to submit their reports, to lay their reports in this way. Those committees did not lay their reports. So those committees are automatically out. They cannot go on oversight. But all of those committees that did not go on oversight and those that went on oversight and laid their reports, please submit your concept note for committee activities. Submit the concept notes to the leader of government business for his vetting and my final action. Proceed.
Bill, the Constitution of Sierra Leone Amendment Act 2025. Committee stage and third reading. The Attorney General and Minister of Justice. The House is also the Committee of the Rule. Weeks of Ms. Cover. Continue proceedings.
Why they block the position? Who is it that block the position? Nah, they put. You can't not do. You can't even get me. No. Over me. I tell you, right? This is not offering. You don't know what it.
Yes, sir.
Yes, sir. Mr. Chairman, our tables and we are cleared off for the state to play by I think the cleaners or administrators, I don't know, and our documents were dumped in the library on part. So most of us are struggling to get our constitutional bill and our constitutional here to refer to for the debate. So I asked that you instruct whoever did that to start to
Mr. Clark, Mr. Clark.
And Honorable Speaker, Honorable Speaker, Honorable members, the Honorable member has personally visited my office and with the claims. And as you all know, somebody was in charge of the chamber during the cleaning of the state opening. I engaged her, Mrs. Fraser, and indeed, I was informed that the notices were put out so that honorable members, because they were approaching. Alright, so what happened, honorable members, they now removed those documents and they took them to the library. They were not disposed, they were taken to the library. So when the honorable member approached me, I again approached Mrs. Fraser to ensure that those documents were sorted out. back for their use, all right, because they needed to fumigate this chamber for a very good use for the very honorable members and for the general public that was visiting this chamber. So that was what exactly happened. I've informed the honorable member that they will get a staff to get the documents sorted and that they will make those documents available.
Mr. Chairman, let me just make it clear. I approached the clerk. What he's explaining to me now is quite different from what he explained to me initially. The documents were taken not by librarians because they are in charge of documentation here. They were taken by cleaners. Most of them don't know the importance of these documents we use. And some documents were under these drawers where we get access to. So they were not taken to library, they were thrown. If you go to library now, you see the way they are disposed. I went there personally on Friday and even this morning to search my own document. It took me almost an hour. So
have you seen your document now?
I have seen mine, but I'm speaking on behalf of most of the NPCs here. So, Mr. Chairman, this is very serious. Whenever such exercise, they want to conduct exercise, they need to inform us. Like he's saying, they never inform us. Like, for example, this is a tiny document. I place it on my table like this. It can cause any harm to this target. I can understand if those are on the floor. So for this, Mr. Chairman, most of us cannot effectively participate this now because our documents mark them so we have to sort that out.
Okay, John, we'll deal with that later. Yes, proceed. Proceed. Yes, we're at page. Mr. Chair, sir. Chairman, sir. Yes, honorable members, we are at the. I think somebody got up. Is it okay now?
Yes, Mr. Chair.
Okay. Yes, we are on page 18 also. 19? No, 18. We are on page 18.
Mr. Chairman.
Yes.
These are consequential provisions. I don't think we will be able to do anything much on them now because they are dependent on some of the provisions we have to accommodate. The only thing that maybe we can do, if we go to page 20, from page 21, from page 21 and page 22, there are things that we can really correct. Again, the issue in page 21 is about draft.
Yes, leader of the opposition, we are on page 18. Page 18. Yes, Honorable Mari.
Yes, because again, this is tied to 32.3 and also connected to the Public Elections Act. So whatever we're going to do here now, we can't do anything here now unless we look at the outcome from the previous aspect of the Constitution. So these are the consequential provisions that will be affected if at all the provisions are amended in the Constitution. So again, only few of them that will be looked at, because even in page 20, during the debate, what was highlighted was drafting. So want to just play with you that we focus on the other aspects of that constitutional provision. They can be done at any time, but I think they are determined by whatever changes that take place.
We have it before us now.
Yes. So
We have to deal with it.
page 22.
Hold on. Do we have anything to say about page 18? We don't have anything to say about page 18. Page 18, yes, Honorable Daniel. Yes.
We wanted to leave for some time.
Okay.
You know, I'm going to
Yes. I will.
ask you when the sessions will begin.
Yes, unfortunately, later. Okay, I'll give you 5 minutes to settle down.
Thank you, sir. Thank you, sir.
In the process, Mr. Chairman, you can think of some of the things that I'm going to say now.
Yes, please.
Yes, on page 21, you can see the third paragraph. I raised that point during the debate. It was talking about issue to the successful candidate a certificate of election in Form D set out in the 5th schedule. Now, we have to be specific here. When you look at the Constitution, has no 5th schedule. Then the 5th schedule in the Public Elections Act have no Form D. So we have to really place that particular aspect. It's a drafting issue, but then again, it's very important if we're talking about forms that are going to be issued out, it's very important that we take that into consideration. Then of course, we're not there yet, but again, you think about that. Page 22, section 21, from the debate, there was that kind of agreement that we're talking about the Political Parties Act, about the registry of political parties, which of course from this end, we argue that it's something not within what we are looking at. So again, that can be taken out of this controversial provision.
I know you've done your assignment and you are in order to make presentations. But we are on page 18. You have been reading throughout this weekend. Yes, Honorable Timo.
So on page 18,
Page 18.
I know we've struck a pin on the qualifications for the Chief Electoral Commissioner. However, I want to read page 18 in tandem with the requirements in page 3 of the same bill.
Okay.
So the requirements that are placed in page 18 for the qualification of the Chief Electoral Commissioner ought to be the same as the qualifications in page 3.
Of course.
So when you look at the two, they're different. So I think it's a matter of harmonizing the requirements and agreeing on them.
Yes. A leader's government business.
Mr. Chairman, I don't know why the EG is wasting time to deal with the consequential amendment. For now, we have said that we really don't need the consequential amendment. We don't need it now. I think we should do us a favor by just removing this whole part from the bill.
Yes, Mr. Speaker, honorable members, good morning. As indicated by the leader of government business, there is a submission that the provisions or the proposals relating to consequential amendments starting from page 18 be put on hold because this is actually in line with section 173 of the Constitution of Sierra Leone, which reads, with your leave, Mr. Speaker, that the provisions of any consequential provisions acts made under this Constitution or any acts relating to citizenship shall not be amended, repealed, reenacted, or replaced unless the bill incorporating such amendments, repeal, reenactment, or replacement is supported at the final vote thereupon by the votes of not less than 2/3 of members of Parliament. So it's a submission that the focus remains on the bill itself right now, and once we get a vote on that bill, and then this House can do the consequential provisions. So that is what Section 173 says. In addition, it is my submission that the consequential provisions.
Leader, can you move? Leader, can you move?
Yeah. And it is also a submission, Speaker, honorable members, that while we move to remove the consequential provisions for now, in fact, the provision relating to proposal relating to clause 21, that one will be deleted completely because it will not be part of the submission.
From 18 to 21.
So from 18 to 20.
From clause 19.
From clause 19
to 21.
Yes, Mr. Speaker.
Yes. So, leader, can you please?
Maybe I'm wrong here. Why do we need to move the Constitution provision? We cannot be back on it.
It's all right. He's the one who is piloting the bill. So if you say that he does not want that again, we cannot
that is correct, but his authority is not above that of the Constitution. The Constitution is very, very clear.
It's all right. It's all right. Honorable, it's all right. Let's do that. Please move.
Chairman, the commitment for the PPRC Act, and also when I asked for the Saturday leave, the fact it was amendment section 85, section 7 of the Constitution, based on such provision 9,109 in the minister made commitment. And also, you are just quoted was the question amendment in line with constitutional provision. And 21 is on the anti provision. We so part 2 that has to do with constitutional amendment made deleted from the bill. So moved.
Any seconder? Any seconder? All those in favor say aye. Those against say nay. The ayes have it. Part 2, deleted. Honorable members, we go back to those areas where we stop pigs and deal with those clauses one after the other. Beginning with clause 1. Clause 1. Clause 1 reads
To be specific,
yes.
to be specific, I think it's 1B.
1B, yes, 1B. Yes. Yes, so what do you say? What do you say, Honorable Mary?
Again, Mr. Chairman, it's the issue of the search committee that we had there. But it's clear, 171.14 is clear about not being bound or whosoever. We have your attention, Mr. Chairman. The search committee is going to sit and make a decision. They will bring forward nominees to the president. But in this constitution, whatever the process, the consultation process that might have taken place, subsection 14 of 171 makes it clear that it's not bound by the outcome of that particular consultation or that advice. 53.3 is also clear on that. So why do we need to bring a group of people together, not for free at some point, spend all the time deliberating, make a decision, while at the end of the day, whosoever they are going to present this decision to is not bound by the outcome of that consultation.
What do you say?
So, again, it's something like the operation was successful, but the patient died. The man you bring in this decision already has the power to even make that decision. So it is against this backdrop that we are saying
consultation process be clearly defined. In as much as, again, he's not bound by the outcome, so why take the powers from him when he can even reject?
Waste of time.
This is the question we're facing. We bring them together, they make a decision, but when they bring it to the president, he still has the power to even reject it. So why not make them? Again, we're looking for some other opportunity to bring people together. We spend resources, just like we're trying to ignore all the other resources or the time and effort spent on the previous consultations, the white papers. So let's not make it a habit of bringing people together. They make a decision, then at the end of the day, we walk away from whatever recommendation. So what we have now is, we have even all the political parties who are not even part of the search committee. So what we are trying to do, to even politicize this other groups that will be speaking through to power. The sooner they have the opportunity to determine who conducts the election, they automatically politicize. That's why we're going to start World War III. Who becomes a member of that particular committee? Because at the end of the day, they are going to determine the result. So again, we can prevent all of this, Mr. Chairman. He has the power. Let's make a decision in consultation with all the parties of the party. I rest my case, Mr. Chairman.
Yes, Honorable Emeke.
Mr. Chairman, a successful operation, the patient dies. Two things be satisfied. The patient is satisfied that he was not abandoned when he was sick. Secondly, the family feel they've done their best. What we seek to address is a democratic credentials that befits our nation. We know the outcome rests on the president, but at least it befits a situation in which the citizens will know there was a process that is credible. Is that too much to ask for? Politicizing this year, so it should not be your worry. Besides, we have people who serve in the executive that were CSOs. Were they not politicians before they came in? Because somebody is telling us he has owned membership 15 years before he became PRO. Let's go to the core of the matter, Mr. Speaker. What we seek to do as a nation is correcting the very mistakes we've had, the very complaints we've had, election in, election out. Restoring the confidence of the people that their votes will count and their votes matters. Restoring democracy to the point where the people have confidence that when I get up in the morning 5 o'clock and I go to that queue, I am voting in the person that becomes the president. And the person who becomes the president has the confidence that I am leading the people that gave me their mandate. It's a social contract theory in which we give them our authority. They give us the social services. Therefore, we are not asking for too much. We are not saying the search committee nominates the president automatically. No. They are only part of the process to ensure we have a credible person in the office. Is that too much to ask for? But the trouble is, we already had a situation of consultation. Are we admitting that we very well knew it was done wrongly? And we were finding a definition for it all this while. We have a president that is so considerate, but yet still he could not do consultation for 8 full years in a manner accepted by the people of Sierra Leone. Are we leaving that again to the same situation of having to define what consultation means for us? If we were supposed to beg, we beg for this. For the credibility of our process, for the credibility of our nation, for the acceptance of our results. Let us just allow the situation we are in. But I find it difficult to ask, what are we arguing over? As a chairman of the committee, the select committee, after doing everything, I report to the speaker, who is the arbiter and who is the head of this house. So my outcome at the committee stage, where I chair, where I should pretend as the speaker, is not finality until the speaker says so. So why is the speaker worried? Mr. Mr. Speaker, in terms of resources, if we want to save resources, let me say this. Even the people out there do not see us as worthy people to be paid. We can save resources by leaving this house and let people have more resources. So I am saying my position is clear and our position on this side is clear. Let us save democracy. Let us assure the people of having an electoral commissioner that befits the status of our democratic credentials.
Yes. Of course, I know.
Our position on this other side was very clear, the true sense of patriotism. Make law not because it's a citizen or the inside or the interest on a normal temperature and pressure on all sides to have the final say for the good of this country. We have made our position. We are going to redact laws in the extant law. We are going to remain the same. And we ask that there is any definition of consultation, we take it to the Public Elections Act, where we do the general administration of the law. Even if they are proposing, you cannot do the administration of the law in the Constitution. You can take it to the Public Elections Act. Define the law. I don't want to go over and over what I've said. I have said the 10,000 number. While the president did for the appointment of the electoral commissioners, I asked my colleague 10,000 numbers that go to the Supreme Court for interpretation. For us, we start with the extra law. We are starting with the extra commission. I respect this. No more submission on this side concerning my no more submission.
Yes, the leader of the opposition.
Yes, Mr. Speaker. I similarly believe that we had ample debate on this topic. And no form of debate will shift anybody's position. We profile in reasons for which we are against that very clause in the Constitution. And with all of the debates, if we still stand our ground, then I believe even if we open another debate, we'll be here for the rest of the day. So I want to crave from your indulgence. You are the head of this house. I want to crave on your indulgence and we proceed with the process. Because it's clear, one of the reasons one of our members stated that even when you define consultation and you have a sitting president who does not go by it, who will reprimand the president for not knowing the Constitution, it will be a job in futility. So we still stand our ground that we're against. We want that very clause in the amendment, and that position is our position.
So, the leader of government business, can you state your position and move a motion?
Mr. Chairman, I have stated I have the Total provision with me. Our provision, during we are in the opposition, presented the BISAC committee as it is, rejected by the then government in 2017. Both the Peter Tucker and the Justice Kawan, in blessed memory, both of them, that said, let us sustain the extant provision that has Rule 32(2) of the Constitution. Whatever definition we have to do, we will address that one in the Public Elections Act. I so move that we stay with extant law.
Your position is that we stay the extant law.
Yes.
Any seconder?
No second, Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it.
Firstly, I want to rise on the SO 46-1.
Order. All of you in the gallery. All of you in the gallery. Don't take part. You are citizens of the Republic of Sierra Leone. So you are right to be here. But you are not right to take part in what is happening here. Otherwise, I will withdraw your right and send you out. So please keep quiet and listen to what is happening here. At the end of everything, you can go to your members in their offices, you can go to their homes and tell them, SO2, oh, I like the way you talk today. But not here. Please, proceed, Honorable.
Mr. Speaker.
Sorry, leader, please.
Yes, Honorable.
Yeah, Mr. Speaker, your time is too old. So I move I also have to suspend it for the business of the House.
Yes, any seconder? Any seconder?
I saw second.
All those in favor say aye. Those against say nay. The ayes have it. Yes, leader of the opposition.
Yes, sir. I rise on SO 46-1 to challenge your ruling, sir, and let it be on the records the number of people who voted in favor. And Mr. Speaker, this is about altering the Constitution, and I'll come to that. But firstly, I stand on SO 46-1 to challenge your will.
Thank you very much, Honorable Leader of the Opposition. So I'm going to put the question again, and I'll rule. Yes, Leader. I'm putting the question again. Hold on.
Yeah, Mr. Speaker, before you put the question, my challenge is as a result of the fact that I am not convinced with the collection of voices.
Yes, that's why I'm putting the question again the second time. All those in favor say aye. Those against say nay. Yes, proceed.
Honorable members, of course, you do not need to have a very loud voice to vote in Parliament. Because if it were that, they would have got to look for those with the loudest voice to be elected in Parliament. Parliament is a house of procedure. We have seen and noticed that during the process, there is immense participation from the gallery. Mr. Speaker, that is why I want us to have a head count so that we can have a specific number of members of Parliament who voted for and those who voted against. That is why I am standing again on SO 46-1 to challenge voice voting that is
Honorable members, a division has been played by the leader of the opposition. A In the circumstances, I call both leaders to call their members who are outside to come in. I'm giving you 10 minutes to make sure all your members are here. 10 minutes, Sergeant Atam. Sergeant Atam.
Yes, sir.
Clear the chambers. All strangers leave the chambers. The gallery will allow the journalists, the reception of the journalists and the party stakeholders, all of you play the well. All of you. We'll also allow the diplomats. The head of the press gallery, identify your members.
and it's okay.
If you're not, those in the gallery, if you're not supposed to be there, you'll be arrested.
Madam President of the Press Gallery, please identify all those that are seated that are not your members of the gallery. Just identify them. And I ask the security members to take them out of the chamber. If you know you are not part of that press gallery, leave the chamber. Mr. Get up and leave.
All parliamentary staff leave the chamber with the exception of the sergeant at arms and the table clerks. With the exception of the sergeant at arms and the table clerks, all staff leave.
If you know you are not part of the press gallery, leave. This is the last warning.
Honorable members, please resume your seats. Honorable members, kindly resume your seats. And if you are not a chamber staff and part of the sergeant at arms, kindly also leave the chambers if you are a staff. Can we get the registered members of the press gallery to kindly sit down? Honorable members, please resume your seats.
Honorable members, I wanted the party leaders to stay, but unfortunately, this is a very strict parliamentary procedure. Normally, in votes of this nature, we don't allow strangers to be around. Because I will allow the leaders, all political leaders, to occupy the diplomatic gallery. Please, leave this area. I'll allow you to occupy the diplomatic gallery. Please, all stakeholders, go to the diplomatic gallery. Sergeant Atal, please guide the stakeholders to the diplomatic gallery.
Chairman, can you specify who will cooperate alliance?
The chairman of the political parties and their secretaries.
Thank you.
Chairman of political parties and their secretaries, and former chairman, former secretaries.
Mr.
Yes.
So do I.
This is not a secret society. This is not a secret.
Honorable leader, this is my chamber. This is my chamber. I don't think you should be arguing like that. This is my chamber. Even for I think we have another vote. People they also get yes, we also sent everybody out. No. Okay, this time we don't want strangers within the bank. They can vote. That's why I told them to go. Please give up your position.
Mr. Speaker, with all due respect, I'm appealing that. Mr. Speaker,
I'll put them. Okay, fine. Members of Parliament are short for exercising their vote. We have seen in cases, you know that in fact, at one point in time recently, while we were on this debate, probably I didn't inform you, somebody was calling the missile. While we were on this debate, coming to the gallery, I didn't inform you. Somebody was calling the missile coming to the gallery. It is for the security of members. This is not a secret society. It is just the security of the members. This is not a secret society. It is just the security of the members. We want APC, 5 from the SMP, and 1 each from all the political parties. And 1 each from all the political parties. From all the don't belong to this category. Please leave. It's not about the code of from this case is about the ruling. Except 5 from either side, and 1 each of multiple is about the ruling. Of course, the diplomats can stay, and the journalists can stay. Of course, the diplomats, former members of parliament can go up the gallery, and the journalists can stay. Former members of parliament can go up the gallery. So, Sergeant Atta,
she has to identify
just tell your officers to occupy the entrances. Nobody comes in. Just tell your officers to occupy the entrances. Nobody comes in. Honorable members, I can inform you, a division has been claimed by honorable members, by the leader of the opposition. A division has been claimed by, in the next 2 minutes, by the leader of the opposition. In the next 2 minutes, we'll be taking the votes. In the next 2 minutes, Sergeant at arms occupy the doors. Sergeant at arms.
Yes, sir.
Sergeant at arms. I'm seeing somebody using that entrance. Sergeant at arms.
Who is that? It's
I'm
closed.
seeing somebody using that entrance. Please clear the chambers, please. Please clear the chambers. Go to the gallery. Please clear the chambers. Go to the gallery.
Don't break it, storm. No, it's not more now. Don't break it. Everybody is there. It's storm. What's doing? Clap. Clap.
Yeah, definitely. By all means, they don't get an award.
This one. Okay, no matter. Tower no cancel, not a problem. We are okay.
1 minute.
We are okay.
Shall be taking the votes. Sergeant at arms, close all the doors. We shall be taking the votes. Sergeant at arms, close all the doors. We'll be taking the votes on the clauses. Just on the clauses. We'll be taking the votes on the clauses. And we'll open the doors briefly just from the close for members, you know, for you to relax yourself. Then we'll come to take the final vote. Let me be, you know, for you to relax. Now we are dealing with the clauses. Then we'll come to take the final vote on the plea. So now we are dealing with the clauses. There is a motion on floor by the leader of government business, and that motion has been seconded on the floor. And the leader of the opposition, and that motion has been seconded and has challenged, and the decision of Mr. Speaker. So we are going to the votes and has challenged the decision of Mr. Speaker. So we are going to the votes. I'm going to ask all those in favor to rise in their seats to be counted. After you have been counted, we also call all those against to rise in their seats and be counted. Honorable members, honorable members, all those in favor of the motion of the leader of government business to the effect that the provision in the extant law remains and that the definition of consultation be done in another act. All those in favor say aye. Aye. Can you please stand in your place? Those in favor, can you please stand in your place and be counted? Mr. Clark.
Listen to the leader. Oh, okay. Where you work? Yes, I will now.
Sit down, please sit down. All those against the motion say nay. Please stand up in your seats. Please rise in your seats and be counted. Are you done? Yes, sir. Okay, please sit down. Yes, Mr. Clark, can you report?
With the leave of Mr. Speaker, honorable members, the ayes 96, the nays 49.
In the circumstances, honorable members, the ayes have it. So the extant law remains.
Mr. Speaker.
Yes, I leader of the opposition.
This is a very critical voting. This determines an amendment to the Constitution. And Mr. Speaker,
Honorable, please keep your undertones. Because we want the public to hear what we are doing here.
because, Mr. Speaker, the committee stage is very critical. In fact, it is the stage that encompasses the real process of changing the Constitution or amending the Constitution. This is the stage where we delete clauses. This is the stage where we insert new clauses. This is the stage where we change the constitutional wording. This is the stage where we substitute previous provisions. This is the stage where we vote on the passing of those very, very clauses. And Mr. Speaker, Section 108 is very instructive. It says that for the amendment of the Constitution, so Section 108, which is an entrenched clause, specifically deals with the amendment of the Constitution. And Mr. Speaker, when you want to change is, you want to change acts, you want to change a comma in the Constitution, it should be followed by 2/3 vote of members of Parliament. Mr. Speaker, let me go to 1089. Let me go to Section 1089, Mr. Speaker. It's very clear. It says, Section 1089. It says, this section, in this section, a references to the Constitution include references to any law that amends or replaces any of the provisions of this Constitution, and B, references to the alteration of this Constitution or any chapter or section of this Constitution include references to amendment, modification, or reenactment with or without amendment or modification of any provision for the time being contained in this Constitution or chapter or section thereof, the suspension or repeal of any such provision, and making a difference, the making of difference of different provisions in lieu of such provision, and the addition of new provisions to the Constitution or chapter or section thereof, and references to the alteration of any particular provision of this Constitution shall be construed likewise. So, Mr. Speaker, it is very clear that Section 108, which deals with the amendment of the Constitution, specific references to non-entrenched clauses in subsection 2 and entrenched clauses in subsection 3. Any amendment to this Constitution does not need less than 2/3 vote. Any amendment, in fact, in this case, the amendment is very clear. It's very clear. Even when you make reference to the Constitution, Mr. Speaker, when you take any wording in the Constitution, even without alteration, you reference it in another act of Parliament, it should be supported by not less than 2/3 of this House. I have had various arguments, especially the one that relates to subsection 1 of section 91, which states except where it is stated, the voting of Parliament shall be by simple majority. But in this case, the exception holds, because we are dealing with section 108, which has to do with amendment of our government, which is the Constitution. So, Mr. Speaker, I take the greatest exception, and we on this side take the greatest exception on the fact that this Constitution should not be amended, or no clause must be changed, or no letter must be changed, or no sign must be changed, be it in committee stage or in third reading with less than 2/3.
I'll listen to just one more position by the leader of government business, and I'll rule. Yes, leader of government.
Mr. Chairman.
I said probably you have more. Okay. Yes,
Mr. Chairman.
Then I will listen to Honorable the leader of government business. I will listen to Honorable Gipa, Honorable Daniel Kroma. Okay, then I will rule. Yes.
Mr. Chairman, based on my standing, Mr. Chairman, yes. Based on my standing in the House, I want Gipa to talk before me.
Okay, Honorable Gipa.
Yes.
Thank you, Chairman. Chairman,
listening to the
honorable colleagues, this is a very crucial moment. Forget about all other tools on this side. Yeah.
Listening to the submission of the leader of government business, we all have to acknowledge that we are making law. This is not engineering. And in making law, you look at the text of the very law that guides the lawmaking that you are making. I refer you to the very section that you made reference to, section 108, subsection 2, and we read it carefully for the public to understand. Thereafter, I will take my seat. Mr. Chairman, honorable members, section 108, subsection 2, which my colleague has acknowledged, that deals with non-entrenched clauses, state thus: a bill for an act of Parliament under this section shall not be passed by Parliament unless A. Before the first reading of the bill in Parliament, the text of the bill is published in at least 2 issues of the Gazette. That has been done, provided that not less than 9 days shall elapse between the first publication of the bill in the Gazette and the second publication, and B. The bill, this is the most crucial part, the bill is supported. It did not say the clause. It did not say the clause. Take note, emphasis 9. The bill, that is the entire bill. The bill is supported on the second and third reading by the votes of not less than 2/3 of the members of parliament. My submission, Mr. Speaker, members of parliament, it is my submission that we are at the committee stage, wherein we are voting on clauses, clause by clause voting, and as such we are guided by the provisions in section 91(1) of the 1991 Constitution, which I shall read as well. Section 91 reads thus. Section 91 reads thus. Mr. Speaker, honorable members. Section 91 reads thus. Okay. Except otherwise provided in this Constitution, any question proposed for decision in Parliament shall be determined by a majority of the votes of the members of Parliament and present and voting. Majority, emphasis 9, which means simple majority. So I will emphasize again for the members of Parliament that are following, when we are voting on clauses, we are not voting on the bill holistically. When we get at a point where we have to vote on the bill, I will concede to your point that it has to be a 2/3 majority. But now that we are voting on clauses, you go by 91 because a clause and a bill are different. My submission.
Yes, Honorable Director. Honorable Director.
Thank you very much, Speaker. Mr. Speaker, before my intervention, I just want to ask a simple question to the honorable members' submission. Simple question to the honorable members' submission. The honorable member from Kailam. Just a simple question for the layman understanding and for the attention of the public, for the attention of all Sierra Leoneans in and out of this country. Just one simple question. Sierra Leone is made up of 14 districts. True or false?
14 provincial districts.
14 provincial districts. Sierra Leone comprises of 14 provincial districts. True or false? True.
Honorable members, please, let me crave your kind indulgence. This is a very serious matter. Please, I'll crave your kind indulgence. You know, when people debate on this side, and when people debate on this side, please let's pay attention so that we get the public to hear what we are saying. Please, it's a plea from me. Yes, proceed.
14 provincial districts constitute the nation of Sierra Leone. Simple question for the layman understanding. If there is border disputes in one of those districts, border disputes in one of those districts by another neighboring country, of which during that dispute, members of our district bordering that neighbor country are being killed, are being maimed, are being raped. Is it a problem of Sierra Leone or not? Let's say for instance Kwanedugu. I came from Kwanedugu and I represent Kwanedugu. Kwanedugu borders Guinea. And Kwanedugu is part of Sierra Leone. If Kwanedugu has problem with Guinea, and then the Guineans come and bombard citizens of Kwanedugu, rape the women of Kwanedugu, kill the people of Kwanedugu, is it a problem of Sierra Leone or is it a problem of Kwanedugu? It's a rhetorical question. It's a rhetorical question. You can answer in your mind. And your conscience can answer as well. The problem of Kwenadugu is a problem of Sierra Leone. And His Excellency the President is President of Sierra Leone, of which Kwenadugu is a part. Mr. Speaker, on that premise, I refer you to Section 91.1. Section 91.1. It reads, except as otherwise provided in this Constitution, underline that exception clause. Except as otherwise provided in this Constitution, any question proposed for decision in Parliament shall be determined by a majority of votes of the members present and voting. Mr. Speaker, you are a lawyer from no mean standing, and the honorable member from Galeon is a senior, and he quite well noticed that this provision, subsection 1 of section 91, has an exception clause as an opening statement. That opening statement is not for nothing. The drafters knew what they were doing by providing that exception clause. Mr. Speaker, you will also agree with me, including my senior devout, that in law, you have rules. Sometimes you call them general rule. You have general rule. And you agree with me that not all, but most of those general rules, some of those general rules has exceptions. There are exceptions to general rules. And in fact, apart from that, there's a third stage. You agree with me in the law of evidence that in addition to general rule having exceptions, you also have what we call exception to the exceptions. You have general rule, you have exceptions, and you have exception to the exceptions. Secondly, you agree with me. You agree with me that all exceptional clauses supersede the general rule. Exceptional clauses supersede the general rule. You agree with me? My senior knows that whenever you have exception, that exception is superior to the general rule. It's not affected by that general rule. It supersedes, it's more powerful, it's more superior, it's more potent than the general rule. Mr. Speaker, honorable members. Mr. Speaker, honorable members, I read the provisions of section 108. But before I read, I want to inform this House that section 108 is clearly, unambiguously, an exception to section 91.1. It's one of the exceptions to section 91.1. A clear exception. It's very, very clear. Mr. Speaker, another exceptional clause in the Constitution is the law dealing with state of emergency, passing state of emergency. State of emergency gives exceptions. It gives exceptions to the powers of the president. The general rule sets limits to the powers of the president. It sets limits to the rights, the human rights of citizens and non-citizens residing in and out of this country. It sets limits. But Section 29 now came. You and I know that under Section 91, section 29, those general rules regarding your human rights, your right of movement, your right of speech, or this and that, the exceptions supersede those ones under 29. And the president has the power to overdo his general power stated in chapter 3. The president under 29 has the power to overdo chapter 3 of the Constitution dealing with basic human rights. You know that very well. Mr. Speaker, clearly, Section 108 is an exception. And I read, without furthermore, I read paragraph B. Paragraph B of Section 108. I will first read the opening statement. Subject to the provisions of this Constitution. Subject to the provisions of this Constitution. When you say subject to the provisions of this Constitution, you can say reference to the provisions in 91.1. Because 91.1 is part of the Constitution. Subject to that provision in 91.1. Subject to any other provision. But I will refer you to the provision in 91.1. Subject to that provision. Let us stand there and then move on. Parliament may alter this Constitution. Parliament may alter this Constitution. Of course, may. Because it is of the discretion whether to pass it or not. We have the supreme power under 105. You know that. May alter this Constitution. What constitutes alter? The verb to alter. Or the noun alteration. What do you mean by the word alteration? In this Constitution, any form of amendments, any form of changes, any form of importation from one act to this one, or taking it to another one, or taking it from one chapter to another chapter, no, it's best fit under chapter 2 rather than chapter 3. It's best fit under section 9 rather than section 1. That's the importation. And even by modification it says, but it reads down this way rather than that other way. It constitutes alteration. And that alteration points to single individual clauses, single individual provisions in each clause. It says that bill, the bill before us here, the bill before us is supported by the second and third reading by the vote of not less than 2/3 of members of Parliament. Now listen. Now listen. Subsection 8 of section 108 for further edification. Subsection 8 of section 108. It reads, maybe I will only stop to the opening paragraph so that I will go to the others. Or if you don't mind, I will read all. Subsection 8 of section 108. Speaker. Mr. Speaker, honorable members, subsection 8 of section 108. It reads, any suspension, alteration, or repeal of this constitution other than the authority of parliament. Thank you, Mr. Speaker. Mr. Chairman, I will start fresh. Any suspension, alteration, or repeal of this constitution other than the authority of parliament shall be deemed to be an act of treason. Now I want you to pay careful attention to this one. That to suspend, to alter, to repeal, only parliament can do it. So now we are dealing with alteration. We are not suspending. We are not repealing. We are dealing with alteration. This alteration now goes, in fact, on three, goes further to say that even references alone, by just making a reference, to a particular provision of the Constitution, amounts to alteration. But I will read for education. References to this Constitution include, listen to this, references to this Constitution include references to any law that amend, replaces any of the provisions of this Constitution. I will repeat this one. References to this Constitution includes, underline the word includes references to any law that amends or replaces any of the provision of this Constitution. Mr. Speaker, without going further, when you talk about provision, a bill is not a provision. A bill cannot be described as a provision. Provision refers to individual clauses. Provision refers to individual clauses. Individual clauses. Mr. Speaker, honorable members, in fact, this one even you don't need to pass the girl. You don't need to pass the girl to understand this mathematics. Let's say the bill has 9 provisions. 9 provisions. I've told you what provision stands for. A bill cannot be referred to as a provision. Provision refers to individual clauses in the bill. Now let's say for instance, you have 10 clauses in a bill. 10 clauses in a bill. And then you say, this is for layman understanding now. You say, those bills gathered together needs 2 goals. Those 10 clauses gathered together are called a bill, are being referred to as a bill. And until it is treated as a bill, before it requires 2/3. But on the contrary, those 10 provisions, in order to pass each, you just need a simple majority. Now let's go this way. The Constitution says you need 2/3. For the 10 clauses put together, you need 2/3. And then you are saying each can go by simple majority. So let's say now we'll go to the first clause. Number 1 clause, simple majority, passed. Number 2 clause, simple majority, passed. Number 3 clause, simple majority, passed. Number 4 clause, simple majority, passed. Number 5 clause, simple majority, passed. Number 6 clause, simple majority, passed. Number 7 clause, simple majority, passed. Number 8 clause, simple majority, passed. Number 9 clause, simple majority, passed. the last and final clause, number 10, simple majority, pass. And now you all come now together. So well, from 1 to 9, you need 2/3, and then the bill cannot pass 2/3. Does it make sense? Does it make sense? If you can go from 1 to 10 by simple majority, and then there is another bridge to cross, and that bridge now, the judge says you need 2/3, and then you cannot cross that bridge. So why waste time? It proves that that is not the intention of the drafters at all. At all. Mr. Speaker, the word passed. The word passed. Am I protected, Mr. Speaker?
Proceed,
Thank you, sir. The word in law, passed, in quotation, passed. You know what it implies? It implies finality. It implies finality. Finality. When a bill is passed, it means it has come to completion. It is now law. That's the legal meaning of the word passed. So let me ask you this question. How can you apply the word passed to a clause? Clause 1 passed, clause 2 passed, clause 3 passed, clause 5 passed, clause 10 passed. And then all bodies together, or 10 come together, they cannot get 2/3 majority, and then it's not passed. So the word passed in law cannot apply to individual clauses. It cannot. Under section 108, the term in law passed cannot apply to individual clauses. Simple majority cannot apply to them. Because under section 108, they cannot be passed in the absence of 2/3. Let me tell you one. Mr. Speaker, section 108 is so selfish. Very selfish. Selfish, oh. I've never seen a selfish clause or a clause more selfish than section 108. Very selfish. So, section 108 sees itself as so important. I am everything. Without me, you cannot live. And everything starts with me. It starts with me. Everything starts with me. Mr. Speaker. Thank you, sir. Mr. Speaker, I refer you to subsection 3. Subsection 3, paragraph A. I will read the opening subsection and then I will stop at paragraph A. Subsection 3 of section 108. Subsection 3 of section 108. Paragraph A. But I will read subsection 3 for better understanding. Say a bill for an act of parliament enacting a new constitution or altering, remember altering, any of the following provisions of this constitution. That is to say, now I will read it again. Because I want you to understand. Indeed, for an act of parliament enacting a new constitution, listen, or altering any of the following provisions of this constitution, that is to say, number one, this section. Section 108. That is to say, me. If you are given 10 oranges to share between 9 people, if you are wise, what will you do? The first orange belongs to who? Me. And then I will share the rest. The first law of nature is Section 108, respect the law of nature. Me first. And when the act says this section, number one, A, paragraph A, this section, it means which section? Section 108. And Section 108, paragraph B of subsection 2 of Section 108 is part of this section. This section. And then it goes to outline the rest, the others. But it starts with this section. This section includes all of Section 108, all. And what this section says, that is why I see Section 108 as jealous. He's very jealous of himself. Once Section 108 has spoken, Section 108 doesn't want any interference, no interference. This section now says, in paragraph B, say it is supported at the second and third reading by the vote of not less than 2/3 of members of parliament. That is part of this section. It is not part of the intent clauses with requiring referendum. No, it does not stand there. It doesn't stand. It started with himself first. I'm saying himself because I see Section 108 now as a human figure. Human figure jealous of himself and very selfish, and he will not tolerate anybody to tamper with what I have spoken. This section. Mr. Speaker, honorable members, in fact, this is for common sense now. For common sense. Our body is made up of so many parts. Our body is made up of so many parts. You have your hand, you have your feet, you have your stomach, you have your eyes, your heart, and the rest. At a point in time, the head, the eyes, the hands, they revolted against the stomach. They revolted. So when me as the hand, I walk, I use the pen and write, the eye says, in fact, I see, I direct you. The brain will say, in fact, I gave you the idea to modify, to make sure, to make sure it is appealing to your examiner or to your awarding contractor or to Mr. Speaker for approval. At the end of the day, when you get your salary, when you get your money, you buy food, under the stomach, enjoys everything. So they rebel. The hand says, I will no longer work. The eye says, I will no longer see. I will rebel.
Mr. Speaker, point of order, please. My colleague, please. Mr. Speaker, Mr. Speaker, I know you are the president of this world. I want all of us to be mindful of the principle of filibuster. I think that is what we are when a filibuster in a legislative process like this is trying to delay the process of coming to an end of a particular process. My colleague has been conjecturing.
All right, you know, it's deliberate. You know why I'm allowing debate? It's deliberate.
No.
Because on this matter, when I rule, my ruling is going to take care of all the other clauses. So that's why I'm allowing debate. Because when I rule, that rule is going to take care of all the other clauses. So it's deliberate, please. Yes, Honorable.
Mr. Chairman, for the order of this House, I will not permit. For the order of this House, and for your respect, I will not permit. I will go ahead. These parts of the body went on strike for about 4 days. On the 5th day, what happened? On the 5th day, what happened? The eyes became dim, can no longer see. The ear can no longer hear. The hand can no longer walk. The feet can no longer take the body from one place to the other. At the end of the day, they all appeal again. Say, Mr. Soma, please, we are sorry. We are sorry for what we did. We are ready to support you now. And then they supported. In the next 1 hour, the human figure started sweating profusely. And then energy regenerates. What I'm saying here, I'm making this illustration to prove to us that Section 108 is a human figure. You cannot divorce any part of the Constitution as being separate from the other. Touching one is touching all. Alteration of one clause is alteration of the Constitution. With the alteration of that clause will not only change, but the entire Constitution will no longer be the same. It will change. Mr. Speaker, the legal meaning of text, T-E-X-T. The legal meaning of text. Text include even a full stop. Even a full stop is a text. And changing a full stop to comma can change the meaning of that particular section. You agree with me? Changing a comma, changing a full stop, removing the full stop, and replacing it with comma can change the intent of the drafters of that Constitution. It can change the overall meaning. Will change. Automatic. Even if the students will know that this particular clause does not mean the way it used to be. Based on the change of that text from full stop to comma. Mr. Chairman, honorable members, in my final submission, I present to this House that the bill before us is a package. The bill before us is a package. What do you mean by the word package? Package is a combination or inclusion or constitution of various segments. Various segments come together and form a package. If one of that segments is removed from the package is no longer the same. I don't know anybody here who used to smoke. I don't know anybody here who used to smoke. Or who smokes as I speak. But for those who used to smoke, or who smoke right now, in my days, we used to buy a cigarette package, Western. That Western, it has 24 segments in the packet. 24 in the packet. 24 in the packet. You remove one stick from that package, it's no longer a food package. Can no longer be referred to as a package. It's not. If one is cut into half, one cigarette stick in that package is cut into half and then inserted again with half, the rest full stick, the one half stick, it's no longer a package because the package has been altered. Mr. Speaker, above all, we are here speaking our minds, speaking of what we know for posterity. And if we are 200 in this world, I want to inform you that there's a 201 person. There's another person that constitutes also 201, and that is who? Almighty God. Almighty God is here listening. And that's what we want, God in us. God in us. You have God in you, your conscience. Our conscience knows very well that section 108, paragraph B of subsection 2 of section 108 cannot refer to clauses to be dealt with by simple majority. No. Each clause amounts to alteration of the Constitution and must need to be done. In the absence of which, Parliament may be abusing the powers given to it under subsection 8 of section 108. Because section 108 excludes all other walks of life, Only Parliament has the power to alter, to suspend, to import, to modify, to even make reference. So if we use that privilege given to us by subsection 8 of section 108 and misinterpret paragraph B of subsection 2 of section 108, it amounts to abuse of office. And it can even amount to treason as well. We cannot misinterpret. Otherwise, it will go against subsection 8 of section 108. Mr. Speaker, on that note, I must say that we on this side, we are for the Constitution. And we are not supporting any undue procedure that will misinterpret the provisions of section 108. The people of this country are listening to us, and they all support the true meaning of this particular provision. And it allows 2/3 majority to change anything. Otherwise, anybody can wake up one day and then just change anything with no issues. It will be easily abused by allowing simple majority. Simple majority can never apply to this section. And when I say this section, I mean section 108. This section applies to all, not to segments. And that's my case for that.
And then give my ruling on this matter.
Thank you. I've listened to my colleague on the other side, the Deputy Leader of Government Business, and the Deputy Leader of the Opposition, and I'm happy he happens to be a lawyer, and he's a long-winded lawyer, but I'm sure during the course of this process, he has not been paying attention. If he has been paying attention, he will realize and he called. I am not attacking him, I'm just saying, please, he said a lot of things, please, today's not the day, please, today's not the day. Not paying attention is not an insult, it's not an abuse.
The Honorable Kalamu made some statements, but I said for your respect, let us respect you. You think I cannot respond? Something came in my mind, in fact, open that one, yes. But I said for your respect, I will let us respect you. That is it will take his there's one for us, and then that's my respect for you.
Thank you very much, Honorable Nkrumah. Honorable members, let's be careful. Let's guide our words.
Mr. Chairman, I will still stand by my words. I know not paying attention is not an insult. Not paying attention is not being attentive. Period. And this House called that in the course of the passage or the review of this bill, when we discussed Section 76, myself and the leader of the opposition, we were against the extension or the enactment of 12 months as the period specified in this Constitution for a civil servant or anybody prescribed by this Constitution to resign. However, Mr. Chairman, you asked for a vote, and we voted. And in that vote, we were defeated by simple majority, and a ruling was made by Mr. Speaker. Mr. Chairman, I have said this process is bent or depends on the fact that we have to be honest. This is the Constitution. The other document is a proposal, a bill, which is not the Constitution as provided for in Section 108. A proposal before Parliament can never alter this Constitution, whether it is dealt with clause by clause or not in the committee stage. It will never change the intent, spirit, and purpose of this Constitution until it gets to the third reading. Mr. Chairman, how can a proposal be treated, and he has read, and I'm sure he understands subject, verb, agreement, he understands the subject, the predicates, and all. So he should understand the fact that the emphasis on paragraph B and the very subsection 2 of section 108 starts with the word the bill or a bill. How can a simple clause that is not in this Constitution, and is a proposal that is presented before this House, end up as a factor to change this Constitution before it's called in? It's never possible. So the drafters of this Constitution, they knew that the fact is you can do anything at any stage, but at the third reading, before it has the mandate of Parliament as provided for by subsection 1 of section 108, that Parliament may alter it. Before Parliament alter it, it must have the consent of 2/3 of members of Parliament at the third reading before it is passed into law. But how can a proposal at this committee stage form part of the bill? I heard him say that if you take a stick of Western, by the way, those of you who are very young, it's white packet, it has a horse, it has red background. My mother was selling cigarettes. I heard his description of Western, and I will also draw his attention to two examples. The first is those that attended Jala University will tell you that they will sit in the first year, in the second year, and in the third year, but they will never get a degree until they pass the comprehensive examination. Mr. Chairman, those who are teachers and those who start to the NCTV exams before they have the opportunity of going to college, I'm sure somebody is there. You will pass all of your exams at Mitulagai or whichever of the NCTV constituent colleges, but you will not have the NCTV certificate that will qualify you for an application for any university until you pass the comprehensive NCTV exam. So if he's talking about common sense, I think common sense should apply pari passu. Common sense should apply pari passu that a clause that is not in this Constitution, that is a proposal brought to us by a minister of government, can never enter or have its way in this Constitution until after the third reading, Parliament takes the vote of 2/3 on the bill as provided by Section 108. So for me, I see this long-winded skilled conversation as a way to try to play to the gallery. And we have passed that. We have been on radios, public radios, national television. We have taken a debate at the magnanimity of Mr. Speaker, even during the committee stage when we are discussing clause by clause. You allow a debate also to ensue. I think that is sufficient. And Mr. Chairman, this House will continue to rely on a source of law, which is President. And the President has been taken on this bill. We have voted on a clause that forms part of this proposal. And that clause will not pass until in the third reading it is voted for by 2/3 of members of Parliament. That is when that clause that was proposed during the second reading would become a law for this country. Mr. Chairman, we rely on your wisdom and we want to progress so that we complete this process as fast as possible.
Mr. Speaker, honorable members, I can't really understand this story. What is before us is a bill. Mr. Speaker, what is actually before us is a bill. For you to pass, I am not going to read the provisions. You know, Mr. Speaker, I guess you read jurisprudence, Jurisprudence, you read that one. It's the logic, the origin, and the underlying theories of the legal systems. That is jurisprudence. I was at private college, I was a law student. It's a very difficult subject. I mean, that's why it's difficult to pass. I know that Mr. Thompson is around, and Dr. Wright. I know they are around. They must be watching us. Oh, Doc is here. Mr. Thompson, you are here. And Ronald Wright will be watching us. The man who used to admire. I did some logic. In composition of a sentence, you have a word. The word constitutes what you call sentence. And sentences, when you constitute them, makes up what you have a clause. And those clauses make up sections. Those sections formulate to have what you call a bill. Simple. So science of philosophy is what you call jurisprudence. Science of philosophy. Science of philosophy. So I'm thinking that the interpretation, going around, merry-go-round, interpreting this, going through this, we are not new. It's not the first time we are amending this constitution. We have done it, simple majority, at the committee stage, clause by clause. Mr. Chairman, it's very clear to us. In this famous section 108 you are quoting, trying to confuse people, we cannot be convoluted with this whole thing. We can't. We can't allow you to confuse us. As I said, I know where they are coming from. And I see them giving us their backs at the end of the ruling. This has to do with the future of this country. Bill is what we have. We are continuing to pass it. We said, for you to pass this one, the bill, it is a bill. The topic is bill. It has to take 2/3. We have done collection of voices in the second reading. We are now at the committee stage. We are now approaching the third stage where you are going to put questions, we do division, and we come now to vote to get 2/3. For clauses, they are explaining. It's 91. Simple majority. We have done this times without number. Over and over. Sometimes these lectures can be very unpalatable to us. When you may go around without making a logical conclusion, you have failed jurisprudence. You have failed jurisprudence. Mr. Chairman, for us on this other side, I still sustain our position. People are explaining sincerity of the law. We have to express that one. This 32. We are talking about for the consultations, for this, we want the instant provision to be maintained. That is the provision they agreed in June 2017. That was agreed upon by late Justice Kawan's report, white paper. We have it here. You all know. We have debated over and over. So we are not filibustering here. We just want the people to understand. And what we are doing is not the origin. That's why I said jurisprudence. The origin is not coming from us. It's talking about President Bill. It's coming from the former administration and also the late Pakaba of blessed memory. What we are doing, we want to put finality to this process. So I don't think if you are teaching law subject and simple English, this is written B. And we said, I still already defined, clauses constitute what you call, put it into sections. Sections, all of these makes up a bill. So we are sanitizing this bill. But when you want to pass it into law, all this issue of alteration, no alteration, for now, it doesn't make sense. If you don't take the 2/3, it's no law. If you don't take the 2/3, it's no law. So, when we cleanse or sanitize the clause by clause, we are going to put a section to these sections, and you put a final question. That is why, even in the 2/3, you have to claim division. When we are at the second reading, you put the question, and we did collection of voices. No dissenting view. That is 46, and you have claimed 46. It's not a bill. We said clause. If you are talking about a bill, you should have talking about let us vote directly. We cannot underscore the integrity of anybody, but let us make some sense out of our submissions or out of what we have in front of us. So, Mr. Speaker, as Honorable Deputy Speaker said, we don't want people to relate to the gallery as if we don't know what you have debated for so long. I will stand here and speak over and over, but we want to put a logical conclusion to this business to make sure that what we have in front of us for now is dealt with simple majority based on passing the particular committee, the clauses we have in form of simple majority. We have settled all the provisions. I repeat myself where I take my seat. 108 says 2/3 for the collection of the bill for second reading and third reading. The bill it itself cannot pass if you don't have the 2/3 majority. What we are doing now is the clauses we are amending, and the clauses have to do with 91. This is not the first time. If they doubt it, I also encourage them to invoke SO12 hands out. I'm not new to these things. We have dealt with them. Amendment of PPLC Act. We did amend clause by clause of this Constitution. Let's go to the answer. That's what we have the records. Precedent. You have amended this Constitution in the 4th Parliament using collection of voices, even when people had dissenting view. The man you call to the assembly, with all due respect to him, SBB and Honorable Chairman Manjubadi are all seated here as Deputy Speaker. They passed the amendment. The election of Speaker and Deputy Speaker, a collection of voices. When you mean they had Salim, we don't want to go 79. We don't want to go to the Hansard. But Mr. Speaker, Mr. Chairman, we are watching. What you are putting to the fore of this country is our sincerity of documents we have presented to this House. That June 2017, we all accepted to sustain this provision, Section 32(3), that has to do with consultations of appointing electoral commissioners. Thank you, Mr. Chairman. Thank you for your response.
Honorable members, I'm going to take my time to explain the reason for my ruling. I will take my time to explain so that everybody is able to understand the reason why I will rule in a particular way. Please, we are all members of Parliament. Please take your Constitution and turn to 91. Section 91, subsection 1 reads, honorable members, in fact, this particular section is not even written in serious legalese. It's written in plain language for all of us to understand. There isn't much legalese here. 91 subsection 1 reads, except, it starts with the exception. except as otherwise provided in this Constitution. Except the Constitution says otherwise. Except this Constitution says otherwise. Any question proposed for decision in Parliament shall be determined by a majority of the votes of the members present and voting. So everything we do in Parliament, all the decisions we arrive at in Parliament, except this Constitution says otherwise, will be by majority of the members present and voting. Now, because this particular section refers to an exception, I will tell you that there are exceptions in this Constitution. Now turn to section 29, subsection 3. Turn to section 29, subsection 3. Section 29, subsection 3, particularly B, but I will read the entire section. Every declaration made under subsection 1 shall lapse. A, I'm not bothered about A, but B. In any other case, sorry. Okay, in any other case, at the expiration of a period of 21 days, beginning with the date of the declaration, unless it has in the meantime been approved by or superseded by a resolution of Parliament, supported by the votes of 2/3 of the members of Parliament. That's one of the exceptions. One of the exceptions. You know, 91 subsection 1 says except. So one of the exceptions referred to in this Constitution is 29 subsection 3B. Now turn to section 119 subsection 9.
For the votes and proceedings. The references, I know the references. I made a note of references.
Now, in section 119, subsection 9, honorable members, let me read. It says, the provisions of section 137 of this Constitution relating to the removal of a judge of the Superior Court of Judicature other than the Chief Justice from office shall apply to the Auditor General. Now, in this 119 subsection 9, reference is made to section 137. Go to section 137.
Yes.
Now, particularly subsection 7. Now, 137 subsection 7 reads, a judge of the Superior Court of Judicature shall be removed from office by the President if the question of his removal from office has been referred to a tribunal appointed under subsection 5 and the tribunal has recommended to the President that he ought to be removed from office. B, if his removal has been approved by a 2/3 majority in Parliament. That is another exception, tied up to section 119, subsection 9. There's another exception, section 137, subsection 10. Go to that provision again. Now, section 137, subsection 10 reads, the Chief Justice shall be removed from office by the President. Now, A says something. B, if his removal has been approved by 2/3 majority in Parliament. I will also refer you to section 173. Go to section 173. Now, section 173 reads, now the provisions, I'll take my time to read, the provisions of any consequential provision act made under this constitution and of any act relating to citizenship shall not be amended, repealed, reenacted, or replaced unless the bill incorporating such an amendment, repeal, reenactment, or replacement is supported at the final vote thereupon by the votes of not less than 2/3 of the members of Parliament. Now, I'm taking my time to make reference, to refer you to all of these provisions for you to know that apart from these exceptions, whatever decision Parliament wants to arrive at here is by the majority present and voting. Another exception is 108. Go to 108. Now go to 108. Now 108, subsection 2, particularly paragraph B. The bill is supported on the second and third reading by the votes of not less than 2/3 of the members of Parliament. Now, you see the law, especially codified laws that are written, you don't perceive them. You don't create your own perceptions about the law. Codified laws that are written, when the drafters want to say anything, they write it. I sense a whole lot of confusion about the Constitution. But when we come to the third reading of this Constitution, I will do a ruling. And that ruling will be referred to the Supreme Court for opinion. You don't create perceptions about the law. If the drafters mean anything, they write it. So apart from all of these exceptions, any decision we want to arrive at in Parliament is by the majority of those present and voting. Now, honorable members, that being said, let me also refer you to the fact that this document we have before us, of course, the Deputy Speaker went to a very large extent to speak my mind. This document we have before us is not the Constitution. Because I sense a whole lot of confusion around this. It is not the Constitution. This document is not the Constitution. And this document we have is what we call a proposed law. It is a proposed law. And whatever we do in this document, line by line, clause by clause, does not affect the Constitution in any way. The only time this document is going to affect the Constitution is after it would have passed a third reading. Then all the provisions there come into play automatically. The day we pass the third reading of this document, that is when all the provisions in this document come into play. Otherwise, this is just a proposed law. It's just a proposal. This document is just a proposal. You know, the drafters were crafty enough. They were so crafty. They know one important stage of this document is the second reading. Because after the second reading, then you go to looking at the bill clause by clause, line by line, paragraph by paragraph. And they know at the third reading, then it becomes law. By dealing with any clause here, does not mean we are amending, we are repealing, we are replacing any provision. In the first place, this one we just dealt with is not even in the Constitution of Sierra Leone. This such a nomination committee is not even in the Constitution of Sierra Leone. So you can't even begin to talk about 2/3 on something that is not even in the Constitution. In the circumstances, honorable members, I rule that our decision, clause by clause, will be by the majority present and voting. Yes, leader of the opposition.
I so much respect you as a person. And my position has always been that we are living a lasting meaning as a nation. This parliament is making the history. And we on this side, totally convinced, we are extremely persuaded that you cannot change east to worse and off to art in this constitution by mere simple majority. With every respect to your ruling, sir, as stated in SO 42, I want you and the general public, the entire world, to note that we on the side will not be a party to advocating or going against the standard of amendment. We have supported various reforms brought to this house. If we are not willing to support reforms, we will never have voted today. But what we did was an expression of our total willingness for government. But our willingness does not mean we should do what we consider as unlawful. So, Mr. Speaker, with all due respect, sir, pending on your ruling, we want the entire world to note that 96 honorable members of parliament are seeking to amend a document that is to be amended by 100 members of parliament. So we on this side cannot be a party to that, Mr. Speaker. So, honorably, sir, with all due respect, sir, I respect your office so much. I respect your office so much. And in fact, I am constrained because of the respect I have for your office. We on this side will honorably, with all due respect to your seat and with all due respect to this parliament, and the people of Sierra Leone who are watching us, people all over the world, we on this side will not be part of an amendment that lacks the threshold of 2/3 majority. So on that note, we are leaving the ball in your court. 96 members. If you want to touch the Constitution, we have the army for posterity.
No problem.
Posterity will hold you responsible. So on that note, I ask my colleagues on the side that we take a peaceful leave and leave the 96 members.
I just wanted to inform you that yes, sir. The sitting is being disrupted again. Yes, sir. At least you. Yes, sir. Yes, thank you.
Let's listen to yes. Carry on. Okay. So we are going to start.
It's all right. Honorable members, please occupy your seats. Occupy your seats. I'm going to be ruling on this subject, and I'll refer the matter to the Supreme Court for the opinion. Can we proceed with the other clauses? Proceed with the other clauses.
Mr. Chairman.
Yes.
Chairman, so
go to the age thing on page 3.
Yes, page 3 on the age. Yes. I think the aging made the proposal during the debate. Order, please.
Order.
Mr. Chairman, however, we have moved the age attached to those qualification.
Sir?
I said, if we are putting a term of 2 years, of 2 terms, you should only qualify to be a commissioner if you attain the age of 65. If you attain the age of 65. We cannot use 2 bars in most legislations in conformities with the law for us to put 2 bars at the same time for 1 provision. So I'm moving at instead of we said he has not attained the age of 65 years, running down to B of that one. If he has not attained same provision under the member of the Electoral Commission, unless he has attained the age of 65. So we are saying.
Okay, we leave it as it is.
No, you cannot be qualified. I've done 2 submissions.
What do you
can only qualify to be a commissioner if you have attained the age of 65. That is 1. But we are now, I'm now introducing another clause.
Yes.
That you have a term limit.
The term limit
of 2 years.
Of 2.
Yes. So and now.
Take note, Mr. Minister.
Mr. Minister,
can you move? Can you move?
Yes. To move that you cannot be qualified to be a commissioner if you attain the age of 65. That is 1. That will come the rendition.
The rendition will be done properly. Any seconder? Any seconder?
I so second, Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it. We proceed on page 4.
Mr. Chairman.
Yes.
We give you the rendition for. I want you to be consistent with other provisions like the agriculture.
We have just passed it. We have just allowed it in principle.
In principle.
Yes.
So we come back to other rendition and we pass it.
Yes. Proceed. Page 4.
Yes, speaker.
And okay, on page 3, there was this provision relating to if he is not a member of a registered political party. Are you maintaining that? If he is not a member of a registered political party.
That causes no harm. We put it just to enhance the process of legislation to qualify, yes, registered what I think we have to do, because there is a clause at the PLC Act that has to do with a registered political party and an active political member. Yes. So we are going to put a registered political party. We will check that one with the drafter. Thank God the drafter is here. Okay. Because they are speaking in two different languages. So at a registered political party, I think we consult the drafter. I will come back to that. But definitely we have to state it. Yeah, thank you.
Yes, Mr. Minister. Is that correct?
Yes, Mr. Speaker, Honorable Members.
Yes, again, whilst I agree, Mr. Chairman, and I'll kindly agree with the Honorable Leader of Government Business. Whilst we're looking at that particular rendition, we also consider, because sometimes it's difficult for you to even put membership, we can talk about engagement in partisan activities.
Okay. Is all right. Is that noted, honorable members? Okay. Yes, page 4.
Chairman, I was expecting, Mr. Minister, we agree that if the masters for the qualification that if you have a postgraduate from a recognized university and has, that is 3, at A, Chief Electoral Commissioner, unless he holds a postgraduate degree from a recognized university, 1, woman 2, has a professional qualification and experience in governance and public sector, at least for the Chief Electoral, at least 5 years.
Yes, we did that amendment.
We did that amendment, right?
10 years or no?
Yeah. Is it 10?
The others are 5 years.
The others are 5. And also for the bachelor degree, when you talk about postgraduate course in the Chief Electoral Commissioner, you can act in that capacity at any time. So why not just say the same qualification for the Electoral Commissioner? For B, the Electoral Commission, unless he holds a bachelor degree of equivalent from a recognized, I think I want to be consistent with the law. For the SPSS, the qualification for the National Security Act, there was a difference in qualification with that of the NS score and deputies, even for CISA. So we said no. You can act in that position at any time. For the experience as you have done here, I can understand. But because you are going to act and that has to do with some level of efficiency and professionalism, I believe that that has to come to the level of qualification in terms of degree. I think they should have a say for a consistency sake in enacting the law. Okay. That has been my position from what's there, been my submission to the House.
And under clause 3, we were supposed to have inserted 61. Amendment of 61.
Mr. Chairman.
Yes.
Mr. Chairman.
Yes.
Yes, I just want to make a quick comment on the recognized university aspect. Yes. So I don't know, there are some universities that are recognized, but then they are not accredited. So I don't know whether we say accredited or just recognized university.
Honorable member, before the chairman comes in, I don't think this is something we have to be labeled on, because we've had provisions that clearly spells out when it comes to the qualification in terms of how we use that particular aspect when it comes to university. I don't think that will be a problem. Thank you.
Honorable members, I think we don't need to engage in further debates. Let's go to the issues as they are, because I don't think there is much contention right now. We just go to the issues and move.
Mr. Chairman, let me honest. Let's just put this clear. We have legislation pre-existing for different institutions. They are part of. We have to understand, so we cannot come back to it.
Of course.
We cannot do the administration of the law.
Of course.
That is why we have other subsidiary legislations. But there is a reason I asked the minister for 108 in terms of fixed election dates. he made a pronouncement that yes, subsequently, those legislation will be in front of all the PLC Act, the Public Elections Act, and also with the provision for the, what do you call it, for regulations. So those things have been taken care of. The University Act are there. Whether you are accredited, there's a whole lot of criteria you have to go through for it to be recognized as whether recognized university or not. What we are interested in, when we are doing our vetting, we now ask the relevant institution to prove to us whether you're coming from a recognized university or whether it's not almost university together. So those things can be there to see. Thank you.
So we are on page 5, not so?
All right, okay, I can't.
Yeah, of course, that one goes through. The revision will now be done. As long as we've agreed in principle. Page 4, page 5.
Well, in page 4, you know, the other day we discussed the issue of staggering when it comes to appointments. But the essence of that was not to allow the appointment to commence at the same time, to ensure institutional.
We agree.
Yes, but what's not clear, I think the terms. It came up. You know, yes, a commissioner shall serve a full term of 5 years from the date of appointment, irrespective of the remaining terms of other commissioners. That's the end of it. There is nowhere that talks about even reappointment. It's only a term of 5 years. So again,
that can be started by proper.
Yes, again, because we've had that for another term of 5 years, like normally you understand reappointment.
Okay. That is on 4 also. Mr. Minister, take note of all of these issues.
Yes, Mr. Speaker, I'd like to make some correction or something.
AG, before, in fact, my attention has been drawn to it by the clerk that it was even inserted on that page.
Yes, certainly.
Thank you.
Certainly, Mr. Minister. So we proceed to page 5.
Mr. Speaker, before we proceed to page 5, with your leave, because of the modifications that have been made, section 32, subsection 4, we propose that some rewarding is done, especially relating to the age of 65 years. And what I've gathered from honorable members, the intent is that if someone has attained the age of 65, then that person is not qualified to be appointed. Emphasis on the word appointed. Chief Electoral Commissioner. However, based on the submission that has been made and as approved by members of Parliament, if someone is already appointed for a term, and then in the course of that term, that person turns 65, he will still continue to hold that office until he or she finishes that term. Because the reading of it now, B, says a person shall not be qualified, B, to hold office as a member of the Electoral Commission, if he's a minister, deputy minister, member of Parliament, or a public officer, or if he has attained the age of 65 years. So which means if under current law, if you turn 65 while serving on the commission, you cease to qualify immediately. So the proposal would be for subsection 4 of section 32 to read, a person shall not be qualified for appointment as a member of the Electoral Commission, A, if he is not qualified to be elected as a member of Parliament, and B, if he is a minister, deputy minister, a member of parliament, a public officer, or if he has attained the age of 65. So that way, that restriction, when you're 65, applies to appointment, not service. That would be the amendment, Mr. Justice.
Yes, Mr. Chairman. So in that case, the issue of reappointment for such a person is null and void.
Are we set on that?
Yes.
Thank you. Are we set? Yes. Mr. Minister.
Yes, Mr. Speaker, we have taken note of the correction. We just wanted to provide that clarification.
Okay, sorry. Yes, so we move on to page 5 also. Page 5.
I think in page 5 it's the subsection 2 was where we stop a B, which of course I strongly believe the leader
on page 5. No, we don't have 2 on page 5.
Or B, I mean B, the B aspect.
Mr. Speaker, if I may,
it's the B aspect.
Oh, yes, no.
Mr. Chairman. Exactly.
Yes. Yes. So it's
Yes.
Yes.
Thank you. And under clause 3, I think we changed 2 to 1.
Yes.
We changed 2 to 1
instead of subsection 2.
I think under the proviso we did an amendment by the insertion of 61 or 61 or something like that. Am I clear on that?
Mr. Chairman, first let us do amendment for the 30%. Other than the proper rendition, but we all accepted that we should have the 30% as enshrined in the Kiwi Act. So we should just import that one.
Yes, and I think there is something related to the executive. Not
yes, so we are here to ask the minister.
You have to guide us.
Yes. Yes, please.
Just a minute, let me come. We need to have in the proper order. That this one has to do with elections. This one has to do with electoral laws here. The one that has to do with the executive, we are saying we place it where we have 61. So it should be in the next page, it should be the other page. So for this we sustain 30% as the Kiwi Act. Okay. So the thing I want the minister to clarify is going to carry the word shall as proposed.
Yes, Mr. Honorable members, for
we still want to have you on that.
For section 35, we will keep the word shall, and for section 61, it will be made.
Okay. Okay.
So the submission.
That's on page 5.
Yeah. So your submission is still in line. Is still in line with only the 30% party nominees for national and local government elections shall be women.
Correct.
So the subsequent provisions in the Public Elections Act remain the same. We don't track that one at all. We don't import them. You know?
Well, yes. The only thing is, when we get to that, we will propose an amendment to section 58 of the Public Elections Act.
So we don't need to go far. So if you accept this one, we now go to Public Elections Act and do the subsequent amendment, because you have said, I also tell us to proceed in line with section 58 of the Public Elections Act. So here we maintain the word shall, Mr. Chairman, and rely on the Public Elections Act to entrench to make a clarification in section 58. Okay. All right.
So is that noted?
Yes, sir.
Then we move on to page 6.
Mr. Chairman, please.
Yes.
I'm not a lawyer, I'm a lawmaker. I just want some clarification.
Yes.
It's simple. One person representing. What is the difference between the two? When can the president appoint without making reference to any group? One person from.
Where is that?
Just this.
Well, Chairman, I think he's talking about his search.
On page 5. On page 5.
No, we have done with that.
Mention the language I'm talking about.
No, forget about the language.
Okay. Thank you.
Yes.
There is no way I intend to be a job, sir. Yes. Once again, there are certain areas where they agreed on, so we understand no need to go for them.
Yeah,
just like they drawing our attention to the areas where we stop pins, and those areas have been highlighted.
Yes, page 6. Page 6.
Mr. Chairman, sorry, sir. I beg to differ. Those questions are not. Those questions were agreed on principles. So what we need to do for the edification of the public, we have brought in all of those provisions. We seemingly agree, but it's also force of law. Yes. So we have to state it.
Yes.
Especially they have worked out that we agree on those provisions, on principles. So what you are doing now, we are taking our time to go across because you stop keeping on them.
Yes.
So I'm now
saying
we have dealt with all of them that
all of them.
61.
Yes.
Making term limit for electoral commissioner. And what you are proposing, that we say, attend it because we say you cannot put two back. The qualification should be the same. And the year of 10 years and 5 years. I remember,
yes,
we agree on those things.
Exactly.
Right? So we have to go over it so that people understand we agree on them.
Of course. So page 5 to 6. Page 5 to 6.
Page 5 to 6. There is an area, the top part of that's section 4. The A and B, there we stock pins. The C and D that had to do with the census, we are finding that. So it was the A and B aspect that we are going to look at, because we're talking about the aging as well, talking about moving the constituencies in such a relation aspect. The A and B, those are the areas that we stock people.
So are we okay now with that? Because there is no more contention. You don't have much contention. So. Are you okay with that, leader of government business? 5 to 6?
Yes.
So those provisions stay? Okay. Mr. Minister, the provisions stay, not so?
Yes. Yes.
Page 6, page 7. We deleted the independent candidate, not so? Yes. And okay, so we are done with page 7. Page 8.
Well, it's clear that in page 8, E, that's where we have the issue of the threshold.
Yes, the threshold. Yes. But there is no more contention.
Well, Mr. Speaker, I'd just like to clarify. I think we made clear and as well that yes, in the bill, we had made a proposal for a threshold of a simple majority of total valid votes cast throughout Sierra Leone, and then to a minimum 20% of the total valid votes cast in at least 2/3 of the districts of Sierra Leone.
But I think you agreed.
Yes. Yes, I just wanted to make clear to everyone, including listening public, that we are agreed with the technical committee made up of the APC and government of Sierra Leone that the amended bill on the floor of this house is to read that a person shall not be declared elected President of Sierra Leone unless at the presidential election he obtains a vote of 50% plus 1 Of the total valid votes cast.
50% plus 1.
Yes.
Okay.
Of the total valid votes cast. So, and that removes the threshold and the simple majority.
So 50 plus 1.
Plus 1, yes. 50
Okay.
plus 1.
Mr. Chairman, this is in line with the tripartite recommendation.
Hold on. Yes.
Chairman, so the one we have in the bill, and we have the tripartite, and this is in line with the white paper in June 2017. More than 50%. Everything is in line. So what we are saying now, because tripartite is so recent and it's in conformity with most of the provisions, so we forget about the threshold, district threshold, and stick to 50 plus 1. Now let me be a little case for the public. If you go to section 42E of the Constitution, the first phase, the proposal we have, what is the expand provision, is 55%. And if there is a runoff, F of that provision, section 42, subsection 2F, say it's going to be simple majority. In 14 days, because you do elections in 14 days with simple majority. So there is not really much difference, I say. But this one is more entrenched, it's more classified in terms of reaching out to other political parties. So some of us will receive another provision from PPRs, from APA, that there is a situation where you will not get the 50 plus 1. What happens? So we are saying for national inclusivity, because we have argued on that
of course, if the law says 50 plus 1, if you can't get 50 plus 1, then you do runoff. Then there's runoff.
So in the case where,
and in runoff, the one who scores the highest wins.
It is majority. So there is a proposal also that instead of going around doing runoff, what about making a coalition with other parties that will give you 50 plus 1? Yes, so you should not do runoff. That was the proposal from the APA, from all political parties. That was the proposal. So if the AG, so we need to discuss it. Mr. Chairman,
yes.
Then the proposal from APA.
AG.
So if this house says,
is it not 50 plus 1, and in the event no political party scores the 50 plus 1, there will be runoff? Yes.
Yeah, and Mr. Chairman, repeating this particular section by bringing in the tripartite recommendation, fair enough. We realize that tripartite recommendation, both parties were there, and the presence also of international community. To be very fair enough, if we import tripartite recommendation to this bill now, and by repealing this today, I think we will join the rest of the world. The entire ECOWAS, as a member of ECOWAS Parliament, I realized that right in this supplementary act, Article 40, subsection 2, is saying countries should endeavor to have uniform laws. I think it is only Sierra Leone that is still going with 55% to make it president. But all of the ECOWAS countries, do your research, they are all 50.1 or simple majority. In fact, to the extent of even AU, 54 countries comprising the AU, all of those AU countries, they practice 50.1 or simple majority. So repealing this age-long draconic law today will help Sierra Leone to join the rest of the world. I so submit.
Yes, proceed.
Mr. Chairman, I also just want to clarify that with this proposal, and of course adopting what the leader of government said. So this proposal, just to be clear, that yes, the 50+1 threshold, which will read, no person shall be elected as president of Sierra Leone unless at the presidential election he has polled a total of 50 plus a minimum, but not less than 50% plus 1 of the valid votes in his favor. And so the threshold, which we see under 2 of that clause, will go away completely.
Of course, we have stated that.
Okay. And
I think what the leader wants to know is, in the event nobody scores 50+1. That regulation has to be done.
The government's position on this for now is, in the default of a candidate being duly elected under the provision that I just read, the 2 candidates with the highest number of numbers of votes shall go forward to the runoff.
More realistic. All those in favor say aye. Aye. Those against say nay. Proceed. Page 9.
Mr. Chairman, just for neatness of proceedings, it's just clear that this aspect of the bottom part of page 8, way to the top part of page 11, we agreed to take all of that to the public elections.
That is very correct, Mr. Speaker.
Yes, all of that. Yes, we take all of that. So that should be the bottom part of page 8, page 9, page 10 also.
To the top part of
page 11.
Just above clause 8.
Yes, we agree. Okay, thank you. Now, the remaining part of page 11. Yes, under this one, we said to which the state is a party, but we decided to remove that to say any criminal.
Yes, to delete that aspect to which the state is a party.
No, not the state. We remove that aspect.
Yes, that's what I'm saying.
And we made it general.
Yes, sir.
Mr. Minister, take note of that. That's for page 11.
The text of this one that you are seeing.
We said in 43, in the event that the presidential candidate is standing trial on a criminal charge, you delete to which the state is a party. Delete that one, to which the state is a party on a criminal charge 1 year prior to the election. So we just delete that aspect. So it becomes general, whether private or state prosecution.
So we also said trial is suspended.
Yes. After. Yes, after. 1 year after. That's for page 11. Page 12.
Mr. Chairman.
Yes.
Yeah, just a clarification. So this goes for purely presidential candidate, not their opponents.
Of course.
Fine.
Yes, page 12.
Page 12, remember the top part of page 12, which has to do B, was deleted.
Yes, this one was deleted. Delete?
Yes, the top part, yes. And also,
we deleted 10.
In fact, 10 was the transitional provision, and we deleted 10 to the top part of page 13.
And we deleted president or.
Yes, because that provision has to do with the vice president, so the word president there was redundant.
Yes. Then under 12E, we deleted expulsion.
Expulsion was replaced with his removal.
So under clause 13?
Well, 13 at some point had a contention for some reason. Again, we can go back again to the AG. We stop a bit on clause 13.
Yes, on 13. AG. We have dealt with that. Yeah, we have dealt with that. Yes, AG, that's it.
you please go over that? Can you please go over that?
Well, I was saying.
There was contention to the proportional representation.
Yes, that was plus 13. That was the only area where we stuck a pin. Yes. The other areas had to do with the removal of the vice president, but the president was inserted and we deleted president.
Yes, we deleted.
Yeah, yes.
No, we are on clause 13.
So yes, I'm just taking it through it.
Yes, Speaker. Yes, we keep the proposal to amend Section 74 of the Constitution to read B, such number of members of Parliament as Parliament may prescribe who, subject to this Constitution, shall be elected through a system of proportional representation. And then we have included an additional link to say with a detailed mode, method of nomination and conduct of such elections prescribed by or under an act of Parliament. And Mr. Speaker, with your leave, I'd like to just provide some context on that.
Yes, please.
That additional link.
Yes,
yeah, that is what. But that is what.
Well, of course.
No, so
then what do you need to explain now?
You are going to bring us
What do you need to explain?
So I'm just trying to provide. So of course we want to keep the name of that. The detailed mode and method of nomination be prescribed in a separate legislation. I think we're on the same page on that. I just wanted to say, if required, I'm happy to provide context on why we recommend that. But if members of Parliament, already have the context that such prescription will be made in a separate law, and we will have a conversation on such proposals. We are happy to lead the conversation on that.
Yes. So on page 14, page 15.
Mr. Chairman, on page 14.
Yes.
We stopped a smaller bill. Well, in the sense that we had to agree on the safeguards.
Yes, the safeguards. Have you done the rendition for the safeguards?
Well, to some point.
Yes.
Because
read them out.
One, with regards, we have to agree on something because it will affect changes in some other areas, which we have to look at. At some point, we'll have to revisit 41. We'll have to revisit 54 because 41, the qualification for president, 54, the qualification for president, also on that particular aspect. Then 56 to 60 ministers, then 75 to 77 members of parliament. And then, to some extent, even if possible, the Citizenship Act was to fall under consequential. So, now, we're going to settle with something because it's going to be clear that certain positions, which were already clear on that day, the president, the vice president, the speaker, the chief justice, those areas are prevented from that particular change. So, let me read something as part of the safeguards. A person who is a dual citizen shall have been ordinarily resident in Sierra Leone for a period of not less than 24 months, immediately preceding the date of nomination or appointment. Other safeguards, we talk about NACIT. And then also on that day, I also raised the issue of disclosure of all foreign citizenship. It was very important because if we consider here as a dual citizen, we must know the other nationality which we held again. Of course, disclose any foreign public office.
I hope Mr. AD, you are taking note. And Mr. Thompson is here also. Take note of all of those issues.
Yes, Mr. Speaker, we did take notes of all of those, and I think we are on the same page.
Yeah, do a proper rendition to reflect that.
And Mr. Chairman.
Yes.
I still have with you that he made a lot of proposals that were making it confusing.
Oh.
Chairman. So I was thinking I should agree not a new issue, putting in place like the layout which you propose, President, Vice President, Chief Executive of Parliament, dealing with different categories, take another category. It has to do with whether we are proposing chief
You can use a legalist instead of having those. You can use a legalist to reflect the position in all of those sections to refer to. Notwithstanding what is in that. So
because
like that.
Chairman, we have to be very careful in dealing with this. Don't forget that there are other discussions.
Yes.
And so we have to maintain, we should be clear, especially with voluntary lives. We have to maintain that law to justify why it cannot be chief of why it cannot be general. You guys can keep it.
No, we don't need it.
No, it's just the proposal I'm making, not that I'm making any submission. I'm still in line with what you are proposing. But I want us to be clear on the text provided to us. If you read the text, it's very clear voluntarily or under any declaration of allegiance. That is what you are, and that is what is in line, the spirit of why we are achieving 6-1. So if you categorize them as we started, for the other categories, so be in line with other existing legislations, it can be fine. I don't want us to go too deep. Where at the end of the day, if you're talking about to be a association for voluntary, you want to be ministers, you have to go and make an amendment in 56. You know that very well, Mr. Minister. So yes, I'm drawing attention. You have to make one amendment 56. So you have to accept it, you have to have a revision, and go back for 56. Because you cannot be a member of parliament, you member of parliament, you cannot be a minister. So if you are making exceptions, you have to go for 56. We want our brothers in the diaspora to be part of us. We have to be there. We have to be careful. We deal both sides of the eye.
What I mean, we have agreed in principle on all of these issues. But it is now for the draftsman to go prepare a proper revision.
But I have now you talking about what you told us. Those ones are too much in this one, like on any, and it was making too naive for us to those things in the Constitution. What I'm just saying, which you have been in principle, that let us go back and look again, we all agree, because this is not about us. This is about our own family members who are abroad, what has happened, because as a son of our family. So what she said that we now look at the legislation, we have with other legislation, so we cannot mix them up. So that when we come, we now put them properly, it's going to the Constitution. So that is it. Okay, thank you.
Yes, all those in favor say aye. Those against say nay. The ayes have it. Second rendition be done.
Clarification, Mr. Chairman.
Yes.
Yes, the rendition is going to be done. But I just want again to make it clear that I mentioned the proposition. Any others could fall into some of the legislation. I list them all. So let's really be clear on that particular aspect.
So what we have agreed when you do the rendition, make sure and say it.
Yes, again,
do the rendition and bring it. Let me see.
Why I'm going over this again? I mentioned the position, the president, the vice president, the speaker, the chief justice. The day I made the submission, there were some other positions, but again, the House never accepted Mr. Sokoto. But we have to bring because I raised a point about the Inspector General of Police, the Chief of Defense Staff, and many more. So let's be clear that day I made a submission, it wasn't accepted.
Of course.
So we have to provide safeguards. We are talking about 24 months.
This is a position that was accepted.
Thank you.
It was an accepted.
And in fact, I also, the honorable leader is busy there. I raised or I highlighted the provisions that we will revisit at some point, together with the draftsmen, of course, 54, 41, and then 56 to 60, and all the rest of it. Again, I just want to go over
Mr. Clark, take note. Mr. Clark, take note of that.
Sorry, I think, Mr. Speaker, honorable members, I think for government in the submission last week. Unfortunately, I left the piece of paper where we had proposed the rendition for Section 76. Look through my file, it's not here. But our proposal was to add a proviso under Section 76 to read as if a person, it's not actually, and I had worked on it, just didn't have it. But we basically say a person who is a Sierra Leonean by birth, but holds the citizenship of another country, we put it in the context of the negative. It shall not be qualified to run for election as member of parliament unless that person has paid local taxes to the community for 5 years preceding their candidacy for such an election, and that person has been physically resident in Sierra Leone for a period not less than 24 months. And then we provided additional language to say that's